What is the 10-year rule in divorce in Michigan? Actually, there is no such thing as a 10-year rule that applies to divorce law in the state of Michigan. What people are probably confusing that with is the law with regard to Social Security. That's federal law. What that 10-year rule means is that if a couple is married for 10 years, the spouse that did not work during the marriage is entitled to collect 1/2 of their spouse's Social Security at the time of retirement. And you get divorced before that 10-year period is up, then when time comes for retirement, then that spouse that was married for less than 10 years is not going to be able to make any claim for Social Security benefits on their spouse's work record. That's why it's really important for so many people to have employment during the marriage. Some cases don't allow for that, and the circumstances don't allow for it because there's a lot of stay-at-home moms that don't work because they've taken on the role of taking care of children and taking care of the household. If they were married for less than 10 years, they are not going to have any Social Security benefits until they establish their own 10-year work record on which their Social Security will be based. Unfortunately, you can't force someone to be married for 10 years, even if you thought that might be an option. Sometimes people might wait a little bit longer so that the other person can make that claim when they do retire. Let me add this. Even though the non-working spouse does not have their own work record, if they're married for 10 years, they have the ability to claim 1/2 of the Social Security benefit of their spouse. That doesn't take anything away from the spouse that was working. It's not taken out of their Social Security benefits. It's simply that the Social Security system and the federal law allows that non-working spouse that's been married for 10 years to collect 1/2 of that Social Security benefit.